All right, we'll move on to Whitman versus Whitman. It's a civil case, so the parties will have 20 minutes per side. Good morning.
Good morning.
Would you like to reserve some time?
Respectfully, yes, if I could have 5 minutes, please.
Certainly.
Thank you. And for the record, Anne-Marie Janusa, appearing for the appellant, Martin Whitman. Good morning. Due process requires that a party be given the opportunity to be heard and to testify and call witnesses on his behalf, and denial of that right is fundamental error. This case specifically is fundamental error what happened at the trial court level. If you're familiar with the facts, the appellant had the right to be able to cross-examine his witnesses, in this case including the minor child of the marriage.
Didn't your client initially object to allowing the child to testify?
Initially, yes. And what happened
and
is...
so at that point they went and took a deposition where the child was subject to cross-examination, and it was videotaped, and that video was played at the trial, correct?
The video was not played at the trial.
The judge did not view the video?
After the fact, that video was not played.
Well, but it was part of what went into the judge's consideration.
Over strenuous objection from the appellant because...
Well, you knew what the video showed. You all were present for it, correct?
Yes, sir.
Right. And so you don't see any problem with the fact that the judge effectively ruled initially how your client had asked him to rule, which is not to allow that child to testify at trial?
The interesting part of this case, Your Honor, is from when the injunction was actually the temporary was first into effect, till when we finally had a hearing, almost 6 months had elapsed. There was a history in between the initial time and the time that we actually had the final hearing regarding the divorce case and the injunction case that were kind of piggybacking each other going through the court system. Respectfully, at that point, my client, part of our defense was that there was fabrication on behalf and collusion between the minor child and the mother, who were both the alleged victims in the domestic violence injunction. When the court, at that point, foreclosed our opportunity to be able to effectively cross-examine the daughter, who was one of the alleged victims, to be able to show bias, motive, or any of the...
Are we talking between the date of the initial videotape deposition and trial?
Yes.
Was there any motion made to redepose the witness?
I believe in my objection I had said that we didn't have the opportunity to fully, and that we would request to be able to clarify for the record, have the daughter come in. There was no showing on behalf of why the daughter could not be there, other than at the time, I believe it's our position, the guardian ad litem got up and said that she would not be able to testify. And that foreclosed our client's right to be able to effectively cross-examine.
Your client had, in an earlier pleading, said it wasn't in the child's best interest to testify.
At that time it wasn't, because he wanted to protect his child. But
so it changed?
During the course of 6 months, unfortunately, people's versions of incidents changed, as well as new witnesses that had come out. And during the course of that 6 months, a lot of instances occurred.
What is your position on the family rule?
I'm sorry, Your Honor?
What is your position on the rule of family rule of procedure that says that a court shall not permit child to be brought to court absent good cause?
Well, interesting enough, the court did allow at one point the minor child to testify, and then at some point overruled itself.
Does that rule apply to this proceeding?
I believe the intent of that rule was to not put children in the middle of a heated custody battle. If you look at a lot of the cases where that rule is used, in this particular case we're faced with...
Are you saying that the rule does not apply, or it does apply?
In the divorce case, I believe it applied.
Does it apply to this case?
I believe the intent was for it to apply, but however, we don't believe that in this specific instance where she's also a victim, an alleged victim, as well as a witness for the appellant's case, we really needed to be able to cross-examine.
Do you have are you aware of any precedent where an appellate court has reversed a trial judge's decision under the rule regarding whether a child should be brought to court to testify? Do you have any? Is there any time that you're aware of that the appeals courts have ever come down the way you're suggesting that we do in this case?
In my research, I have not found a case on point regarding that. However, I have seen in criminal cases, and I can't tell the court one way or another.
I mean outside the context of criminal case where there's constitutional rights of confrontation. That's a different issue, isn't it?
I could not find any cases.
So one of the,
Yes,
I mean,
sir.
admittedly, the order of the trial court is sparse as far as findings go. In fact, they're non-existent.
Yes, sir.
However, when I look at the motion to preclude the child's testimony filed by the GAIL in this case, she alleged, and I didn't see where this was disputed by the parties, that it would not be in the child's best interest because the child had been admitted to a psych unit at a hospital for self-mutilation behaviors since the dissolution had been ongoing, that the child has depression and an anxiety disorder for which he's taken medications. He's a physician and counselor. I didn't see where that was disputed in any way. In fact, it seems to me, based upon the earlier motion by your client to preclude the child from testifying, he understood, at least at that time, that this child had some issues that would not be enhanced by active participation in the litigation. So even though the trial judge didn't make the requisite findings under the statute, is the error harmless given the unrebutted assertions made about the child's mental and psychological condition?
Originally, the allegations was the daughter suffered from an eating disorder. During the duration of the representation, it became clear that there was nobody definitively gave the child a diagnosis of an eating disorder. We could never get a definitive, was it anorexia, was it bulimia? And then during the course of the representation, the way the case tracked is, it appeared that there was facts that were really not facts all of a sudden started to take on a mind of its own, and an urban legend was coming throughout the course of this case. For example,
getting back to Judge Orfinger's question to you, the allegation went, to add a little bit to it, there was allegation made that your client went to speak with the child about the circumstances involved, and the child suffered an anxiety attack, had to leave school. There is nowhere in this record that I see that rebuts those allegations. And so please, if you could get back to that question.
But there was, because there was nobody who ever definitively, just in the pleading, it was in the pleading, we had hearings on it, that never definitively came out on the record or in the record during the course of any hearings. There was conjecture and there was conclusion. There was no expert.
If those contentions are made and the standard is that your client, as the proponent of the evidence, has to show good cause, wouldn't the burden then be on you to say, well, this stuff is all a bunch of hokum. She doesn't have this, she doesn't have the other, and it isn't going to hurt her in any way?
I believe we tried to do that at one of the hearings, and we were foreclosed by doing that. And by putting her on the stand, the only people that ever saw any allegations of this were their witnesses. We had a supervised visitation between a doctor, Dr. Garamoni, as well as my client, who disputed, and we did present that testimony at the final hearing. So respectfully...
I'm sorry, can you cite where in the record you were foreclosed from challenging the allegations as to her psychiatric and psychological history?
I believe during the course of the injunction, the court heard testimony and then heard from Dr. Garamoni. An argument took place regarding that, and we weren't able to fully go back into what had happened regarding the minor child. And there were multiple hearings regarding this specific case that unfortunately occurred in both the injunction case and the divorce case. But it's still our position that because the daughter was not able to be questioned at the ultimate hearing, Mr. Whitman's rights were violated and due process was violated. And respectfully, because our position was that there was collusion as well as misinformation being given to this 15-year-old child, by not allowing us to adequately put her on the stand and let the judge, if he had questions asked, we believe again that we were foreclosed from doing that and that his rights were violated, due process was violated. As for the second issue, I understand that Ms. March has been taken out of the proceeding because the minor child has been dismissed from the proceeding. However, at the time when the injunction was being heard, the court did abuse its discretion when it allowed Ms. March to play a dual role.
What would be your remedy on your second point?
What we would like to see is have the court...
What's your remedy?
The remedy is to have another injunction hearing with solely...
Why is that?
Because
how's that going to make any difference?
The two cases were inexplicably intertwined, and I believe if the court grants us the ability to have a new hearing, we believe...
No, okay. Let's just take your second point in isolation here.
Okay.
Isn't the error that the trial judge made one that it did not prejudice your client?
No, we believe it did prejudice my client.
Well, I know you believe that. Tell me how it prejudiced your client.
Because Ms. March was able to give testimony to the court as well as advocate for the child, which the statute prohibits that. It specifically says...
No, I understand the statute. We're charged with the responsibility to reverse harmful error. You know, you're arguing a legal point here that really doesn't seem to go to the merits of the case.
It goes to the heart of the case.
We send it back for a new hearing and correct the trial judge on your second point. Trial judge is going to rule the same way that he or she did the first time, right?
I don't believe so. I think because at that point we'll have more clarification.
You never know, right? I mean, you never know. You may be able to convince the trial judge that he or she weighed the evidence improperly or incorrectly or what have you, right?
Well, I believe at that point, yes, because if you look at from the beginning of the record to the end, Lisa March's role was never clearly defined. And but for that confusion and not being able to know who is what in the case, as a guardian ad litem, we would have been allowed to take her deposition. She'd only been on the case less than a month when all this took place, and Mr. Whitman was foreclosed at that point because we still didn't know what the role is. Eventually, we were able to take Ms. March's deposition, but that was after the injunction case had already been heard. And so for Mr. Whitman, he was prejudiced, and if the court does grant him, which is the relief we're looking for, a new hearing, it's our belief that when the court hears all the evidence and testimony, and if the daughter is allowed to testify again, we believe the result would be different, and that Mr. Whitman did in fact suffer.
Is your concern that Ms. March was appointed as the GAL and the attorney ad litem, or is it that she filed pleadings in what you believe became an advocacy role?
It's both, but primarily the second one is more of the concern that goes to the heart and cuts through the case. That the pleadings had inaccurate and hearsay information.
Well, I understand you didn't like what she put in the pleadings, that they weren't helpful to your client's position. But what I'm trying to understand is if she had been, let's assume she'd just been appointed the guardian ad litem, and that she had hired Joe Blow to be the attorney for her. I'm trying to understand again why this isn't harmless error, simply because she could have filed exactly the same thing. It simply would have had a different lawyer's signature on it.
But she would have been subject to cross-examination to see what the basis of her allegations were.
Well, but she should have been subject. I mean, did anybody preclude you from taking her deposition from the get-go?
She wasn't involved in the case from the get-go,
unfortunately. Well, but from whenever she became involved in the case.
Timing-wise.
Did anybody ever say you try to set her down for depo and they said, oh, wait, attorney-client or something?
Initially, yes, and then after the injunction hearing, I was able to take her deposition, which is not part of this record, but after the fact, I was able to.
Well, where in this record is there some evidence that you tried to depose her and either she refused or the court precluded it?
There wouldn't be, because the role was blurred, and that's what our argument was. We didn't know what the role was, so whether to depose her or not depose her never came to fruition, because it was less than a month after she had been appointed that the hearing took place, and at the time we were still arguing about what her actual role would be, and that's where we believe the prejudice comes into effect.
You've got just right at 5 minutes.
If I could stop at this point.
Okay, thank you, ma'am.
May it please the Court, my name is Andrew Morgan on behalf of the appellee Judith Whitman. Come before the Court today. The appellant presented testimony at the final hearing sufficient to satisfy due process in this case. He testified himself twice. The court-appointed psychologist to conduct supervised visits, Dr. Garamoni, testified. The child testified herself by way of Family Law Rule 12.407 from a deposition taken 1 week prior to the final hearing in this case. The appellant cross-examined all witnesses presented by the appellee at the final hearing, and on page 210 of the trial transcript, when the appellant rested his case, he did so. The court said, "Are there any other witnesses?" And to quote the appellant, the response was, "No other witnesses." Not, "We want to call the guardian ad litem, we want to call Dr. X, Dr. Y, Dr. Z to attack any of the assertions made." They rest their case with no other witnesses. And I would like to address what I believe is important procedurally in this case, and that is the motions that were presented by both sides back and forth on the testimony of the daughter, whether it was going to be deposition or whether it was going to be in the courtroom. And it began in June 8th, 2007 with the wife, the appellee, filing a motion asking that the daughter be allowed to testify. The husband objected, but the court issued an order in early July allowing it. The next motion to address this was filed by the appellant in late September, and the appellant's motion to take testimony of child through deposition. I would like to read that they argue that a show cause hearing is pending before this honorable court on the matter of Judith Gail Whitman and Rachel Whitman v. Martin Whitman, injunction against domestic violence. And they state, "Wherefore, respondent," who is the appellant here, "respectfully requests this honorable court permit the testimony of Rachel E. Whitman through deposition, the child of the parties, at the aforementioned hearing," the aforementioned hearing being the final testimony. The judge then, 3 or 4 days later, grants that order. Just over a month later, the deposition of Rachel Whitman is taken in chambers with the appellant, the appellees there. It's videotaped. There's an opportunity to cross-examine the child at that time. You have that as part of the record, the transcript from that proceeding. Following that, the appellant files a motion to allow testimony of the minor child, a contradiction of their earlier motion. And then, and only then, does Lisa March file a motion essentially trying to keep what had been ordered in October.
Does your client object to the presentation of that testimony as well?
My client does not object to the testimony by way of deposition.
No, I'm talking about live testimony.
I did not object, but we would have had the guardian ad litem not been in this case.
So both sides changed their position. Your client took the position initially to allow the child to testify, and so the positions have swapped. So what?
I believe it's harmless. In fact, the judge changed his position. And why did he do that? I would submit to the court for the reasons that you've alluded to. You've got a child who's under psychiatric care from multiple doctors. It's in her own deposition. She talks about seeing certain doctors every week and other doctors once a month. It was an exacting emotional toll on this child. And the judge made the proper finding under 12.407 that the testimony was not necessary. At least the live testimony was not necessary. I submit to the court that under Petrie, that if perhaps the judge had restricted the testimony of the child at all, not through deposition, not at all on the stand, that maybe there may be an argument for the appellant. But the fact of the matter is that the child did testify. that they were given an opportunity to cross-examine. But it was done under 12.407, and the commentary to that rule says that the judge needs to determine if it's necessary and relevant. Well, the judge in page 7 of the final transcript says to the appellant after they're finished arguing, you have made your you've made your argument. I've heard this before. The child's not going to testify. The trial. So the standard review here today is whether that decision was reasonable. Whether in the judge's judicial discretion he made an error. And certainly, in light of the fact of the emotional issues this child's undergoing, the fact that there's been already one deposition a week before the prior hearing where all parties had an opportunity to cross-examine, the judge just simply felt it wasn't necessary. The appellant in the final hearing did not properly preserve what they believed the child would say in giving live testimony, and they couldn't do so here today because in the final transcript hearing they argue that they believe that a lot of these allegations have been falsified and manipulated by the mother as well as other participants. And they state we need to be able to inquire as to what circumstances were surrounding the daughter's basis of knowledge. That's their argument for why it's necessary to have the child come into court and give live testimony. The court considered that, found it was unnecessary. I would like to address the issue of Lisa March and whether the appellant was prejudiced by the appointment of Lisa March.
So by starting there, you are in agreement, or you concede that it was error to have that dual role?
I certainly concede to the court that we are talking about a misapplication of the law. That the statute clearly says...
I'm not sure I appreciate the difference between your answer and Judge Cohen's question. He said you concede that there was error, and you said you concede that there was a misapplication of the law. Aren't they the same thing?
They are the same.
Okay, well then yes would have been a much more succinct answer.
I apologize to the court.
Gotcha.
Yes, it was error, and this court, in the questions to the appellant, I believe understands our position, and that is that error is harmless. The motions that were filed by Ms. March were the proper issues of a guardian ad litem. So when the court asked the appellant, we're really talking about a different signature here, aren't we? That's what we're talking about. The appellant can't prove, but for the error, the result would have changed here in this case. But I would also argue that this issue is now moot, that the injunction against the daughter has been dismissed.
It's not moot if it's somehow prejudiced, him at the hearing, right?
All right.
I mean, that's really the issue, was he somehow prejudiced at the hearing, right? You say no, they say yes.
Well, I don't think that the question is one of prejudice. It's a one of discretion in applying 12.407. The appellant was not prejudiced. He was allowed to present witnesses. The appellant cites a string of cases where the appellant is not permitted to present testimony. They presented the testimony of the daughter, but the court just said, we're not bringing the daughter back in here just over within just about a week to testify again. They found that unnecessary, that the first deposition was sufficient.
I'm sorry, I thought you were on the guardian.
Well, I am, but they all end up tying back together.
Okay.
But whether the guardian, I would submit to the court that it was harmless error, that it did not affect the outcome of the case, and the appellant did not make that showing in their brief, and they did not make that showing here today. We would ask that the court affirm the trial court's ruling, both as to the exclusion of the live testimony of the daughter pursuant to Rule 12.407 and find that the error committed by the lower court as far as a guardian ad litem, attorney ad litem, was harmless error. Does the court have any other questions for the appellee?
Thank you very much.
Thank you.
Noosa, you've got about 5 minutes remaining. 5 minutes and 11 seconds.
Thank you. I don't think I'm going to need it all, but I appreciate it. The standard here is the judicial discretion and the abuse of the judicial discretion. I don't believe there's any argument as to it is error for the court to have appointed Ms. March as both the attorney and the guardian ad litem. And the reason why there's a rule that states they're to be different is because the role for each is different. As the attorney, you have certain rights and privileges, one of them being the attorney-client privilege. When the line was blurred as to what Ms. March's role was, it prejudiced the appellant as well as the appellee to some regard, because as a guardian ad litem, they would be subject to having the deposition taken and being able to testify on behalf of the minor child as the voice to the court. Because from the beginning the role was blurry, it in effect quashed the opportunity for Mr. Whitman to be able to present his case or to question, and thereby obviating the ability for Mr. Whitman to be able to show that the basis for the knowledge was incorrect. And in regards to the daughter, the same thing. If the daughter was there to be able to testify, because at that point during the course of the trial, there were inconsistencies of things that were not even addressed in the deposition, because at that point they were unknown to the appellant. So respectfully for this court, we're asking for a new hearing, because Mr. Whitman's rights were in fact violated and due process was violated. And at that point, let the trier of fact go back and put us back at a level playing field, that if Ms. March is in fact the attorney ad litem, then she can advocate on behalf of her client. And if she's the guardian, then it gives Mr. Whitman the opportunity at that time to find out what the basis of knowledge is at that point. And I'm not going to use any more of my time, and I appreciate your attention.
Thank you.
Thank you
Thank
both.
you.